Chevron Doctrine takes away courts' authority to interpret laws. More people will go to court because now there is no deference, and court will look at it from their perspective and interpret and see what agency is saying is correct or not. So you're going to see a lot more litigation. You're going to see a lot more inconsistent decisions.
How is this related to the Safe Jobs versus DHS case? I'm asking it specifically because we want to understand how this is going to impact the H4 EAD in the future.
Safe Jobs case is that this organization challenged the H4 EAD, the courtesy premium processing, adjudication of H4 EAD can go away.
Things like these cannot get changed overnight. So
with Chevron gone, it is not that it's just bad. It's good as well.
Hi everyone, I am Priya and welcome back to another episode with It's OKR. And if you're new today, It's OKR is a content platform for South Asian immigrants and we aim to educate, entertain and empower them. We have with us Sonal today. Hi Sonal, how are you?
Good, Priya, and you?
Good. And if you've been following It's OKR for a while, then you know Sonal very well at this point. We have created a lot of content together. She's an immigration lawyer. I'll leave the details in the description box if you're new and want to get in touch with her. In today's video, we are going to discuss the following things. So stay tuned and follow along. The first thing is we'll understand the Chevron Doctrine. We'll understand Safe Jobs versus DHS and how it's related. We will also understand the steps needed for the EAD to actually go away. And then Sonal, based on her experience, will talk us through what could happen as a worst case situation when the new administration, if and when the new administration comes later in the year. Hopefully, with all this information, you will be more prepared and understand fully what the process is. Sonal, the big question is, there is so much speculation around the H4 EAD. Can you help us understand what the Chevron Doctrine is?
Sure. So Chevron Doctrine was a judgment that came like around 40 years ago. And what that meant was that when courts are looking at interpretation followed by an agency of a statute, they were required to give deference to agency's interpretation. So statute is what the Congress has passed and written, and sometimes it's not that clear what it means. And agencies, through regulations, basically interpret that and then come up with implementation based on those regulations. When somebody challenges that and it goes to court, the courts under Chevron Doctrine were required to give deference to agency's interpretation, rationale being they are the experts. That agency is the expert, they know what they're doing, they are interested with the job of implementing all these policies, so their interpretation should be given deference. So it made challenging agency, it could be any agency, right? It could be USCIS, it could be EPA, it could be FDA, any agency, when they are interpreting the statute and coming up with regulations based on that, that could be challenged. But it was hard to overcome that because courts were required to give deference. Now that Chevron Doctrine is overruled by Supreme Court in a latest decision, Loper-Bright, what they have said is that Chevron Doctrine takes away courts' authority to interpret laws. So it says that court's job is to interpret law. So when we ask them to give deference to an agency, they are not doing their job. So courts should be the agency when somebody challenges any regulation or statute. Courts should look at it and interpret the law themselves without giving any deference to agency's interpretation. So now what this does is that there will be a lot more litigation, in against every agency's regulations, right? More people will go to court because now there is no deference, and court will look at it from their perspective and interpret and see what agency is saying is correct or not. So earlier, court will not go into whether this is a correct interpretation or not. They would just give deference saying, because agency is interpreting it this way, we are going to give deference to their interpretation. But now they will have to interpret it themselves and then decide whether agency's interpretation is correct or not. So that's what the Chevron doctrine is and what it has done when it is overruled. So you're going to see a lot more litigation. You're going to see a lot more inconsistent decisions because now every court can have a different opinion about how. So somebody suing on the same regulation in Texas could have a different outcome. Somebody suing in New York could have a different outcome on the same regulation. Somebody suing in California could have different outcomes. So it's going to be a lot of inconsistent judgments and decisions coming out of this event that has happened.
Sonal, how is this related to the Safe Jobs versus DHS case? I'm asking it specifically because we want to understand how this is going to impact the H4 EAD in the future. So help us understand a little bit of that. And if you could also give a little bit of a summary on what the Safe Jobs DHS case is for anyone who doesn't know. And I think that would be super helpful.
Sure. So Safe Jobs case is that this organization challenged the H4 EAD. They challenged that the executive branch did not have the authority under the statute for them to give this work authorization to H4 visa holders. So that's the challenge. Now, courts in that did not agree with them. They said that one, Chevron Doctrine comes into play, that if the agency has interpreted the statute, that they have the authority under the statute and the language, whatever it is in the statute, and they are interpreting it to be that they have the authority and they have taken these steps to implement that authority and use that authority, then under Chevron Doctrine, we are giving deference. But also under the statute, the language is that the Attorney General is authorized to determine time and conditions of non-immigrants who are coming to US, and that includes whether spouses of those non-immigrants can stay here, can work or not. So that language in the statute gives this power to executive branch to grant this work authorization. Now, this Safe Jobs decision was basically referring to another case, which was regarding F1 OPT and STEM OPT. So when F1 OPT was granted and 17-month STEM OPT and 24-month STEM OPT was additionally granted, that regulation was also challenged in court. And in that court, in that case, the court said that they have the authority and also Chevron, we have to give deference and blah, blah. So Safe Jobs District Court said, no, we agree with the defendants, they have the authority. And Safe Jobs then filed a writ in Supreme Court, and Supreme Court declined to entertain that case, but then they filed an appeal, which is now pending before the appellate court. Now, why there was so much chatter about this is now people are saying because Chevron is gone, what's going to happen is appeals court now going to look at it okay, Chevron is gone, then, we are going to challenge this again. So we'll see that. Supreme Court judgment also says in Chevron that all the cases that have already been decided based on Chevron deference are not automatically overruled, right? That was the law, and the cases were decided based on that, so it's not automatically overruled. But what most likely is going to happen, that is in this case in appeal where it is appeal, they are going to go back to, there is another deference standard which is called Skidmore. That's another case from years ago, and that's much narrow deference, much limited deference.
What is the deference?
Deference, when you give deference to agencies' interpretation, but it is more limited. So they might go back to that, where they will check the reasonableness of the agency's action, how it was implemented, whether they have exercised their authority reasonably, and what steps were taken, and whether it was like in the context of the whole scheme, whether it makes sense. So that might happen in the Save Job USA case now, with the appeals case that's pending, but we'll see how that goes. But also, there is another Supreme Court case recently which has widened the statute of limitations, which means earlier it was 6 years. So you could challenge government agencies' interpretation or any regulation that they have promulgated within 6 years of its being implemented. But Supreme Court now has said that it's not 6 years. It is basically whenever any plaintiff is hurt or get injured from that regulation, they can bring a challenge. So now, say 20 years later, anybody can challenge who can show that they have been injured by that regulation. So does that open up that now H4 EAD regulation or these F1 OPT regulations, can these be challenged now? Because it's more than 6 years that they were implemented. So under the new widened statute of limitations, it is possible that a new challenge from a different organization could be brought, like any other organization can bring challenge to H4 EAD or F1 OPT, but it's not going to be, in my opinion, it's not going to be that easy to just like, because Chevron is not there, it's not going to be like, just thrown away, because there is statutory authority for government to issue these work authorizations, and that's what was decided in Save Jobs case earlier also. But again, if it goes back to court, we'll see how the court interprets it, and they will get like a new chance to challenge it, and the court's new chance to look at it and interpret it and give their decision on it.
So super helpful. I think what would be interesting for anyone listening to understand is, because there is just so much noise on the internet around the H4 EAD, what is the process going to look like given if a new administration comes? So say a new administration comes, is it like as simple as signing a couple of documents and the H4 EAD goes away? Walk us through what that process looks like so that it eases out a little bit of the panic that is there right now.
So the H4 EAD, when it was implemented, it was implemented following the procedure that's there in the APA, Administrative Procedure Act. So whenever an agency has to promulgate any regulation, there is a procedure that they have to follow, which is like they will have to propose a rule, then they will have to open it for comments, and then analyze those comments and take into consideration those comments. And then sometimes they make some adjustments based on the comments, sometimes they don't, depending on like whatever they're doing, and then they publish it after that. So there's like a whole process. Once an administration follows that process like properly, which is prescribed, it is not that like new administration will just come and sign a document and it just goes away. It's not easy to just, basically take it away like that. Because even if they do it, that action now can be challenged in the court. Right? Okay. Because if you want to take away, then there is a process that they have to follow in APA to take that regulation away. And so it's very cumbersome. It's very difficult to take that away. It's not that easy. And the worry is that, if the new administration comes in and they are not in favor of this, what can they do? 4 years ago, there was an administration which was not in favor of a lot of immigration-related policies, but they did not take away the H4 EAD. All the action-based work authorization, DACA is one of them. It's still there. Yes, there were challenges, and new DACA applications are not accepted, but the program is still there for the people who got it. They are renewing it. So it's not just like with a stroke of pen, you can just take away.
Yeah.
It's much more difficult than that. But yes, there are other ways of like making it more difficult, or new policies can come into place. And again, you're dealing with an agency, and agency changes its policies, but then those are challenged. So it's not going to be as simple as just take it away. But there might be other issues that we might see if there is an administration change.
So, given your experience, help us understand what is the worst case situation that people should be prepared for or can expect.
It's difficult to predict policy wise what's going to happen, but we saw like what was happening. There was delays, renewal for EAD was like insane. There was biometrics requirement for every time you file an H4 extension, which was delaying it. So earlier there was like, if you file H1, H4 EAD together in premium as a courtesy, you would get the H4 and H4 EAD approved along with the H1. Even if not in premium, if you file it together, it would, whenever the principal applicant's case is getting approved, H4 and H4 EAD would also get approved. But then they stopped it, and that courtesy was taken away. That was just a courtesy. It's not regulation that they have to, there is no premium processing for H4 and H4 EAD. So that was just a courtesy. They could take that away again, right? And that would mean that now you're waiting for 6 months, 8 months, 12 months for your EAD. Now, this administration had given flexibility of like work authorization. If your H4 is pending, H4 is approved, but you could work for more than 180 days. At some point, it was like 500 days because there was so much backlog. So all those actions which are agency based could change, right? You could see that there will be more delays, premium processing. Now also, with this administration, premium processing fee has gone up, but also time has gone up. It's not 15 calendar days anymore. It is, 15 business days, which means it's 3 weeks, 21 calendar days. So those little things can change. Mainly, I would be like, process might slow down across the board. You might see interviews coming back for green cards, for employment-based cases. Like right now, we don't get any interviews for employment-based cases. We don't get interviews for most of family-based cases also. But that can come back. The biometric requirement can come back. The courtesy premium processing, adjudication of H4, H4D can go away. So all those things are there which can happen, which has happened in the past. So that might come back as well.
No, thank you so much. Super helpful. Any closing thoughts to avoid panic? I know you almost covered everything, but any closing thoughts for people who are just very nervous?
Well, it's not just like overnight, it's not going to go away, right? So it's not like in like a blink it can go away. There will be a lot of there's a process that needs to be followed, or it will, and if there is an executive action, like at least an effort to do that, it will be challenged. So there is a lot that's going to happen before it's just going to go away. But yes, a lot of stuff and a lot of these work authorizations are based on executive actions. But as long as those are drawn from some authority that's being given to executive branch by the Congress in the statute, it can survive like it has survived in the earlier challenges that has been brought against them in the court.
Thank you so much. I hope everyone who's listening feels a little more relieved and feels they have a lot more information around H4 EAD and what might happen. So appreciate you sharing that. But just to summarize, what you mentioned was Chevron Doctrine can just open up more litigations. We can just see a lot more different challenges happening with that, with Save Jobs DHS case. It was something that was started to kind of challenge the H4 EAD. And then with Chevron Doctrine, we just expect more such things to keep coming. around the way the EAD was kind of issued. It followed an entire process. So it's not that it can go away overnight. There is a whole process that needs to happen. What people should be prepared for is there could be delays again, biometrics, etc., to slow down the process. But things like these cannot get changed overnight. So appreciate you sharing all of that information. Yes, one more thing. Yes.
One more thing I would like to mention is that, with Chevron gone, it is not just that it's just bad, it's good as well in immigration context, right? Because if you look at, um, you know, there is a Kazarian case where when you do an EB1, you have to meet the criteria, and then there is a second step of final merit determination, which is just USCIS standard or interpretation. It does not have any statutory basis. It's coming from a dicta in a Ninth Circuit Court, and USCIS adopted it as their policy. That could be challenged, right? A lot of people will have more basis to challenge USCIS denials, for that matter. Whether it is H1B, L1, EB1 cases, NIW cases, they will, if you get a denial, you will have more basis to challenge it in the court, because you're going to say they're not interpreting the regulations and statute correctly, and denies wrong. And then the court is not going to give deference to their interpretation, right? The court will look at your case and interpret it whether they did the right thing or not. So it's not all wrong, but it's not all good as well, because when we look at these executive actions, it might go the other way, but it also means that it gives people a lot more, reason to challenge their individual cases denials in the court as well.
Got it. Thank you so much. Appreciate you joining. And for everyone who's watching, I hope this was helpful. Please leave comments, and hopefully it eases some panic for you. If things aren't going your way, remember, it's OKR and they will eventually turn around. With that, this is Priya and Sonal signing off. Have a wonderful day.